My name is Haley Morrison, and I was 32 years old when my parents took me to court. Diane Morrison is my mother, and Scott Morrison is my father. They were suing me over the estate of my grandfather, William Parker, a retired judge who raised me after they left me as a baby. The case was about his will, but the real conflict had been building for more than 3 decades. The hearing took place in a quiet civil courtroom on a weekday morning. My parents arrived early and sat together at the plaintiff's table with their lawyer. They looked calm and confident, as if this was a matter they expected to resolve quickly. I arrived alone and took my seat at the defense table without speaking to them. We had not spoken directly in years. When I walked in, my mother noticed me immediately. She rolled her eyes and leaned back in her chair, whispering something to my father. My father did not look at me at all. He focused on his phone, then adjusted his jacket and crossed his arms. Their lawyer glanced at me briefly and then continued explaining something to them in a low voice. The courtroom settled as the bailiff called the session to order. Everyone stood when the judge entered. Judge Marcus Brennan took his seat and began reviewing the case file in front of him. He flipped through several pages, reading carefully. At first, nothing about his expression suggested this case was any different from the others scheduled that day. Then he looked up. His eyes moved from the paperwork to me, and he stopped reading. He looked at me again, this time more closely, and then back down at the file. The pause lasted long enough for the room to feel uncomfortable. My parents were still facing forward, unaware that anything had changed. Judge Brennan placed his pen on the bench. "Just a moment," he said. He looked directly at me. "You are Haley Morrison, the defendant in this matter." "Yes, Your Honor," I replied. He nodded once and leaned back slightly in his chair, continuing to look at me. Recognition crossed his face, slow but unmistakable. He turned his attention to the plaintiff's table. "And you are Diane and Scott Morrison," he said. Their lawyer answered for them, "Yes, Your Honor." Judge Brennan paused again before speaking. "I need to disclose something before we continue. I worked closely with Judge William Parker earlier in my career." My mother stiffened. My father finally looked up. Judge Brennan continued. "If either party objects to me presiding over this case, now is the time to say so." Their lawyer leaned toward them and whispered quickly. My mother's confidence faltered. My father looked annoyed, as if this was an unnecessary complication. After a brief exchange, the lawyer stood. "No objection, Your Honor." Judge Brennan nodded. "Very well, let us proceed." He looked back at the lawyer. "You may begin with your opening statement." That was when the case truly began. 3 months before that courtroom hearing, my grandfather died in his sleep. His name was William Parker, and he had spent more than 40 years on the bench before retiring. He was 87 when he passed. He lived alone in the house where I grew up, the same house where my parents left me when I was 3 months old. The funeral was large. Judges, attorneys, former clerks, and politicians filled the chapel. People I had never met came up to me and spoke about my grandfather's career, his fairness, and the decisions he had made over decades. I stood at the front and delivered the eulogy because that was what he would have wanted. I spoke about his work, but also about who he was at home, because that was the part most people never saw. My parents arrived late and sat in the back row. They did not speak to me before the service. My mother kept her sunglasses on until the last moment. My father stared straight ahead the entire time. When the service ended, they left before the reception began. That was the first time I had seen them in more than 10 years. A week later, I met with my grandfather's attorney for the reading of the will. I did not expect anything significant. I assumed I would receive personal items, maybe his watch or a few books. My parents attended this meeting. They sat across from me, calm and quiet, already discussing what they might do with their share. The attorney began reading. Everything went to me. The house, the accounts, the investments, the savings, the life insurance, every asset my grandfather had built over his lifetime. The total amount exceeded $3 million. The room went silent. My mother spoke first. She said there must be a mistake. My father asked if there was another document. The attorney handed me a sealed letter. It was written by my grandfather. He explained his decision clearly and directly. He stated that the inheritance was intentional and final. He also stated that he anticipated the will might be challenged. Then the attorney handed me another folder. Inside were bank records showing monthly payments my grandfather had made to my mother for more than 20 years, $3,000 every month. The total amount was over $800,000. There were also emails and text messages, requests for more money, promises to visit that never happened, excuses, delays, cancellations. The attorney told us my grandfather had prepared this documentation in advance. 30 days later, my lawyer called me while I was at work. He told me my parents had filed a lawsuit. They were claiming undue influence. They were claiming my grandfather had been confused. They were claiming I had manipulated him. That was when the case moved from private grief to public confrontation. And that was how we ended up in that courtroom. After the lawsuit was filed, my lawyer asked me to sit down with him and go through every detail of my life connected to my grandfather. He did not ask because he doubted me. He asked because he knew my parents would not stop at accusations. They would try to rewrite the past in whatever way benefited them. The lawsuit claimed my grandfather was mentally unfit when he changed his will. It claimed he was lonely, grieving, and easily influenced. It claimed I isolated him from his own daughter and positioned myself as his only support. It did not mention that my parents had already received money from him for decades. It did not mention how rarely they visited. It did not mention who actually lived with him, called him, and showed up consistently. My lawyer warned me the case would not be quick. He said estate disputes like this were not about truth, they were about endurance. Whoever broke first usually lost. My parents assumed I would break. They assumed I would settle. They assumed I would give them money to make the problem disappear. They were wrong. The first formal hearing was scheduled for 6 weeks later. In the meantime, their lawyer began requesting documents, phone records, emails, calendars, financial history. They wanted proof of my grandfather's mental decline. They wanted evidence that I controlled his decisions. Instead, they found the opposite. My grandfather kept detailed calendars, every visit, every phone call, every canceled plan. Years of records showed the same pattern. My name appeared constantly. Their names barely appeared at all. They requested medical records. The records showed regular checkups and no cognitive impairment, no dementia, no confusion, no diagnosis that supported their claims. That did not stop them. Their lawyer added a new angle. He claimed emotional manipulation. He claimed I turned my grandfather against my mother after my grandmother died. He claimed I took advantage of grief. The court approved depositions. My mother was deposed first. She described herself as a devoted daughter who had been pushed away. She said she tried to visit, but was made to feel unwelcome. She said my grandfather became distant after my grandmother passed and relied on me too heavily. She said I inserted myself into decisions that were not mine to make. My father's deposition followed. He claimed he respected my grandfather but avoided him because of tension. He said he wanted to be involved in my life but was discouraged. He said money was never the issue. Then the financial records were introduced. The monthly payments, the additional transfers, the requests for help when businesses failed, the gaps between visits. After that, the tone changed. Their lawyer stopped sounding confident. He began asking for extensions. He began narrowing arguments. He began focusing less on facts and more on emotion. The court date was confirmed. My parents were confident anyway. They believed blood would outweigh evidence. They believed the courtroom would see a daughter wronged and a granddaughter overstepping. They did not know who the judge would be. And they did not know how prepared my grandfather had been. The day of the main hearing arrived faster than my parents expected. By then, the case file had grown thick with documents, records, and sworn statements. My parents had reviewed the same material I had. They knew what existed. They knew what did not. Still, they came to court convinced that confidence would matter more than proof. Their lawyer met them early that morning. I arrived later and took my seat without speaking to anyone. We had been instructed not to interact. That was fine with me. There was nothing left to say. When court was called to order, Judge Brennan reviewed the case summary aloud. He confirmed the claims being made by the plaintiffs. undue influence, mental incompetence, manipulation by a caregiver. Each accusation sounded heavier when spoken out loud, even though none of it was new. My parents' lawyer began by asking the court to recognize the emotional complexity of the situation. He emphasized family. He emphasized grief. He emphasized blood relationships. He asked the court to consider how loss could cloud judgment, especially for an elderly man who had recently lost his wife. He did not mention calendars. He did not mention bank transfers. He did not mention the years of absence. Judge Brennan listened without interrupting. He took notes. He asked no questions. That silence made my parents uncomfortable. They shifted in their seats. Their lawyer continued speaking, filling the space. When it was my lawyer's turn, he did not raise his voice. He did not dramatize anything. He told the court the case was not about emotion. It was about consistency. He said the evidence would show who showed up and who did not. He said the evidence would show who depended on money and who depended on presence. Judge Brennan scheduled witness testimony. My mother was called first. She walked to the stand carefully. She dressed conservatively. She spoke softly. She described her childhood, her early pregnancy, and how overwhelmed she felt at 18. She said leaving me with her parents was temporary. She said it became permanent without her consent. She said she tried to stay involved. Then my lawyer began asking questions. He asked how often she visited during my childhood. He asked about missed school events. He asked about holidays. He asked about phone calls that were never returned. He asked about the monthly payments. She hesitated. She corrected herself. She said she could not remember exact numbers. The records were entered into evidence. Dates replaced memories. Amounts replaced explanations. My mother's testimony ended quietly. My father followed. He was less careful with his words. He admitted he avoided my grandfather because he felt judged. He admitted he relied on financial help when his business plans failed. He said he believed family support should not require conditions. The court asked him to clarify. Support or entitlement? He did not answer. By the end of the day, the courtroom felt different. The confidence my parents had arrived with was gone. Their lawyer asked for a recess. Judge Brennan granted it. Testimony would continue the next morning. That night, my lawyer told me to rest. He said the hardest part was still coming. Tomorrow, I would testify. And after that, there would be nothing left to hide. I was sworn in the next morning. I did not look at my parents when I took the oath. I focused on the judge and answered clearly. My lawyer began with my childhood, not to create sympathy, but to establish a timeline. I was born when my mother was 18. 3 months later, my parents brought me to my grandparents' house. They said it would be temporary. It never was. They left and returned only occasionally. As I grew older, the visits became less frequent. My grandparents handled everything: school enrollment, medical care, daily routines. They attended every event that required a parent. My parents were not present for those things. When they did visit, the visits were brief. My lawyer asked how often my parents called. I answered honestly: inconsistent when I was young, rare when I was older. He asked who paid for my education. I answered honestly: my grandparents paid for everything. He asked who I lived with after my grandmother died. I answered honestly: my grandfather and I lived together. I checked on him daily and had dinner with him every week. The questions were direct. The answers were factual. Then my parents' lawyer began his cross-examination. He suggested my grandfather depended on me emotionally. He suggested that dependency gave me influence. He suggested I benefited from being the only person consistently present. I did not argue. I answered that my grandfather made his own decisions. I answered that he continued managing his affairs until the end of his life. I answered that he never discussed his will with me. The lawyer asked if I knew I would inherit everything. I said no. He asked if I expected it. I said no. He asked if I believed I deserved it. I said that was not my decision to make. The judge watched closely. He interrupted only once, asking me to clarify how often I saw my grandfather in his final years. I answered clearly: every week, more often when his health declined. The lawyer tried again. He suggested my parents were pushed away. I answered that no one stopped them from visiting. He suggested I controlled access. I answered that my grandfather answered his own phone and opened his own door. He suggested I turn my grandfather against his daughter. I answered that my grandfather formed opinions based on decades of behavior. The questioning ended. The courtroom was silent when I stepped down. Judge Brennan called for a brief recess before closing arguments. My parents did not look at me. Their lawyer leaned in close, speaking urgently. They were no longer confident. They were calculating. And they were running out of options. When court resumed, closing arguments were scheduled for the afternoon. Until then, the judge reviewed additional exhibits that had been entered after testimony. My parents' lawyer objected to several documents, but every objection was overruled. The records had been properly obtained and properly filed. The final exhibits were simple: calendars, bank transfers, email chains. Each document showed dates and actions without interpretation. Together, they showed a pattern that could not be argued away. My parents' lawyer stood first for closing arguments. He spoke about family obligation. He spoke about regret. He spoke about how people change with age and grief. He avoided specific dates and numbers. He focused on emotion because facts were no longer helping him. He argued that my grandfather had been lonely after his wife died. He argued that loneliness can distort judgment. He argued that a granddaughter's presence could become influence even without intent. He asked the court to set aside the will and divide the estate fairly. When he finished, my parents nodded as if reassured. Then my lawyer stood. He did not speak about love. He did not speak about pain. He spoke about consistency. He spoke about responsibility. He spoke about evidence that covered more than 30 years. He reminded the court that undue influence required proof, not suspicion. He reminded the court that mental incompetence required diagnosis, not assumption. He pointed out that my grandfather had documented everything long before his death. He pointed out that the plaintiffs had received substantial financial support during his lifetime. He pointed out that absence was not a single mistake, but a repeated choice. When he finished, the judge did not respond immediately. Judge Brennan reviewed his notes slowly. He read sections of the file again. He asked no further questions. Then he spoke. He said the court would recess for deliberation and return with a ruling. The wait felt longer than the entire trial. My parents whispered to each other. My mother's hands shook slightly. My father stared straight ahead. Their lawyer avoided eye contact with both of them. When the bailiff called us back into the courtroom, everyone stood again. Judge Brennan returned with a folder in his hands. He looked directly at my parents before speaking. That was when I knew the decision had already been made. Judge Brennan began reading his decision without raising his voice. He did not summarize arguments or restate emotions. He addressed only what the court was required to decide. He stated that the plaintiffs claimed mental incompetence and undue influence. He stated that the burden of proof rested entirely on them. He stated that the court had reviewed testimony, documents, medical records, and financial history. He said the evidence did not support either claim. He stated that medical records showed no cognitive impairment. He stated that multiple witnesses confirmed my grandfather managed his own affairs until his death. He stated that the will was drafted with legal oversight and included safeguards anticipating a challenge. He then addressed undue influence. He said undue influence required proof of control, isolation, or coercion. He said the evidence showed the opposite. He said the decedent maintained independent communication, made independent decisions, and documented his reasoning over many years. He stated that the court observed a clear pattern of financial dependence by the plaintiffs and consistent presence by the defendant. He stated that absence, when repeated over decades, became a fact, not an accusation. Then he delivered the ruling. The will would stand as written. The plaintiff's petition was denied in full. My mother let out a sound that was halfway between a gasp and a sob. My father stiffened in his chair. Their lawyer lowered his head slightly and began gathering his papers. Judge Brennan was not finished. He stated that the lawsuit lacked sufficient merit and had caused unnecessary expense. He ordered the plaintiffs to cover the defendants' legal fees. The courtroom went completely silent. The gavel came down. The case was closed. My parents did not speak. My mother stared straight ahead, frozen. My father stood abruptly and turned toward their lawyer, his face tight with anger. I remained seated until the judge left the bench. As people began to file out, my lawyer leaned toward me and said it was over. I nodded, but I did not move yet. Then my mother stood and walked toward me. She called my name. I did not answer. She reached out, stopping a few feet away, and said she wanted to talk. Her voice was unsteady now. The confidence she had carried into court was gone. I stood. I told her there was nothing left to discuss. I told her the court had already said everything that needed to be said. She tried again. She said she was still my mother. I told her that the people who raised me had already been buried. I walked past her and left the courtroom without looking back. That was the last time I ever spoke to either of my parents. For several weeks after the ruling, nothing happened. No calls, no letters, no messages. The silence felt deliberate, as if my parents were deciding whether to disappear quietly or try something else. Then my lawyer called. He told me my parents had filed a notice of intent to appeal. They were not appealing the facts. They were appealing the process. They claimed bias. They claimed the judge should have recused himself because of his past professional connection to my grandfather. They claimed that connection influenced the outcome. The filing did not change the ruling. It delayed closure. My lawyer explained that an appeal would not involve new evidence. It would involve reviewing transcripts and procedures. He also explained that appeals failed more often than they succeeded, especially when the record was this clear. Still, it meant the case was not over. The appellate court accepted the filing and scheduled a review. No testimony, no witnesses, just documents and written arguments. My parents did not need to face me again. They could continue the fight from a distance. Their lawyer submitted a brief arguing that Judge Brennan's familiarity with my grandfather created an appearance of partiality. He argued that even if the decision was legally correct, the process itself was flawed. My lawyer responded with one sentence repeated throughout the filing. Disclosure was made, no objection was raised. The appellate court requested additional clarification on that point. Transcripts were submitted. The moment was clear. The judge disclosed the relationship. The plaintiffs declined to object. The record showed it happened before testimony began. Weeks passed. Then months. During that time, I returned to work. I focused on cases that had nothing to do with inheritance or family. I did not check court updates every day. I knew there was nothing more I could do. One afternoon, my lawyer called again. The appellate court had issued its decision. The appeal was denied. The court ruled that disclosure had been proper, that consent had been given, and that no procedural error existed. The original ruling stood in full. There would be no further hearings. No further delays. No remaining options. The case was finished. That evening, I went to my grandfather's house alone. It was quiet the way it always had been since he passed. I walked through rooms I had lived in for most of my life. Nothing had changed. Everything was exactly where he left it. In his study, I opened a drawer I had not checked before. Inside was a sealed envelope with my name on it. I did not open it right away. I already knew whatever was inside would explain why he had been so certain. I opened the envelope at the desk where my grandfather used to work. Inside was a handwritten letter and several folded documents. The letter was dated 2 years before his death. He wrote that he knew the will would be challenged. He wrote that he had watched my parents long enough to understand how they operated. He wrote that they did not act quickly, but they did act persistently when money was involved. He said he wanted no confusion about why he made his decision. Behind the letter were copies of financial records I had already seen in court, but there were additional notes in his handwriting besides several entries. Short sentences, dates, reasons, explanations for why he continued sending money even when visits stopped. He wrote that he kept paying because cutting them off completely would lead to confrontation while he was still alive. He wrote that he preferred peace while he could still manage it himself. He wrote that the will was meant to settle everything after he was gone, when pressure could no longer be applied to him directly. One page listed every time my parents asked for money in emergencies that were not emergencies, failed plans, shortfalls, promises to visit that followed each request. None of those visits happened. At the bottom of the page, he wrote one sentence. "This is not neglect on my part, it is refusal on theirs." I sat there longer than I planned to. 2 days later, my mother called. I did not answer. She called again the next morning, then again that evening. No messages were left. On the fourth call, I answered. She did not ask how I was. She did not ask if we could talk. She said she wanted the letter. She said she knew my grandfather must have left something explaining himself. She said she deserved to see it. She said it was her right as his daughter. I told her the court had already decided what she was entitled to. She said the court did not know everything. I told her the court knew enough. She accused me of hiding things. She accused me of enjoying the outcome. She accused me of turning everyone against her. I told her that nothing had changed. I told her the records existed before the lawsuit. I told her the letter changed nothing. She asked if my grandfather mentioned her. I did not answer. She waited. Then she said she knew he regretted his decision. She said parents always regret choosing grandchildren over children. She said I would understand when I had my own family. I told her the conversation was over. She said this was not finished. I hung up. That night, I scanned every document my grandfather left behind and stored copies with my lawyer. I did not trust silence anymore. Silence was how problems returned later. A week after that, my lawyer called again. He said my parents had made an informal inquiry. They were asking whether any personal letters existed. They were preparing something. And whatever it was not over yet. 2 weeks after my lawyer warned me, a process server showed up at my office. He asked for me by name and handed me a sealed envelope. Inside was a notice of a separate civil filing. My parents were not challenging the will again. They were claiming something else. They were alleging wrongful exclusion from personal property. The filing argued that while the will covered financial assets, it did not explicitly list personal documents, letters, and private records. They claimed those items belonged to them as immediate family. They demanded access to my grandfather's study, files, and personal correspondence. It was not about money anymore. It was about control. My lawyer read the filing carefully. He said it was weak, but not meaningless. Personal property disputes were harder to dismiss quickly. They relied on interpretation rather than numbers. They could drag on. The court scheduled a preliminary hearing. This time, the judge would be different. My parents arrived early again. They sat closer together than before. Their lawyer spoke less confidently than he had during the first trial. He focused on narrow points and avoided eye contact with me. When the judge entered, there was no recognition. No pause, no history, just procedure. Their lawyer argued that as biological children, my parents had a right to personal family materials. He framed it as sentimental. He framed it as emotional closure. He framed it as unfinished business. My lawyer responded that the will explicitly transferred the entire estate, including contents of the home. He stated that personal letters written by my grandfather were his property and were lawfully inherited. He also stated that no request for such materials had been made before the trial concluded. The judge asked one question. Are the plaintiffs alleging these materials were hidden during the original proceedings? Their lawyer hesitated. He said no. The judge asked another question. Are the plaintiffs alleging these materials changed the distribution of assets? Again, the answer was no. The judge took notes. He scheduled a follow-up hearing and ordered both sides to submit inventories of disputed items. After court, my parents followed me into the hallway. My father spoke first. He said this did not have to get ugly. I asked him why it was happening at all. He said they just wanted the truth. I told him the truth had already been recorded, ruled on, and finalized. My mother stepped forward. She asked if my grandfather ever wrote about her. She asked if he said anything kind. I did not answer. She said silence was proof. I told her silence was what she had practiced for 30 years. They left without responding. That night, I went through the study again. I cataloged every letter, every note, every record. I scanned and labeled everything carefully. Not because I intended to give them anything, but because I wanted no room for accusation. At the bottom of one drawer, I found another envelope. This one was not sealed. It was addressed to no one. Inside was a single page. It read, "If they come looking for this, it means nothing I gave them was ever enough." I understood then that my grandfather had expected this. And that he had planned for it too. The second hearing took place 10 days later. By then, both sides had submitted inventories. My list was complete. Every document, letter, notebook, and record in the house was cataloged and dated. My parents' list was short and vague. It referred broadly to personal correspondence and family materials without specifying anything concrete. The judge reviewed both filings in silence. My parents' lawyer argued that the absence of specific descriptions was unavoidable because they did not know what existed. He claimed my grandfather may have intentionally concealed materials that belonged to them. He suggested that withholding those materials caused emotional harm. The judge asked how that harm could be measured. The lawyer said it could not be measured financially. The judge asked what legal remedy they were requesting. The lawyer paused, then said access. Access to the house, access to the study, access to the files. My lawyer stood and responded that access had already been granted during the probate process. He reminded the court that my parents chose not to inspect the property at that time. He also stated that there was no legal basis to reopen possession once ownership had been transferred and affirmed by appeal. The judge asked one final question. Is there any evidence these materials were excluded with malicious intent? The answer was no. The judge closed his notebook. He dismissed the filing. He stated that the court would not allow continued litigation over items that were clearly transferred under the will. He warned that further filings of this nature could result in sanctions. My parents said nothing as the ruling was delivered. Outside the courtroom, their lawyer did not follow them. He shook my lawyer's hand briefly and walked in the opposite direction. My parents approached me again. This time, my father did not speak. My mother asked if I had read everything my grandfather left behind. I said yes. She asked if he ever mentioned forgiving her. I said no. She asked if he was angry with her at the end. I said he was prepared. She stared at me for a long moment, as if waiting for something else. When nothing came, her face changed. The pleading was gone. What replaced it was calculation. She said this was not how family treated each other. I told her the court had already answered that question. That night, I received an email from an address I did not recognize. It contained one sentence. You may have won the cases, but you do not control the story. There was no signature. I forwarded the email to my lawyer. He replied with 2 words. Save everything. That was when I realized the conflict was no longer legal. It was personal. The next move did not come from a court. It came from outside. 3 days after the second case was dismissed, a journalist emailed me. She said she was working on a story about family inheritance disputes involving public figures. She said my grandfather's name had come up. She asked for comment. I did not respond. The next morning, my lawyer called before I reached my office. He asked if I had spoken to the press. I told him no. He told me my parents had. They had given an interview. They did not mention the rulings directly. They did not accuse me by name. They spoke about being cut off, about being erased, about a granddaughter who took everything. They framed it as abandonment, not accountability. The article went live that afternoon. It did not accuse me of crimes. It questioned motives. It asked whether influence could exist even when courts said otherwise. It implied that silence meant guilt. By evening, messages started appearing online. Speculation, assumptions, people who did not know any of us decided what must have happened. My lawyer advised me to stay quiet. He said responding would only extend the narrative. The next day, a second article appeared, then a third. Each one repeated the same claims with slight variations. Each one used anonymous sources. Each one framed the story as unfinished. That afternoon, my mother left a voicemail. She said she did not want this to go public. She said she was forced to speak because I refused to listen. She said the story could still be corrected if I cooperated. She said I needed to do the right thing. I deleted the message. 2 days later, my lawyer forwarded me a draft complaint. It was not filed yet. It was a defamation warning. My parents were threatening to claim that I was deliberately withholding personal writings to damage their reputation. They alleged that my silence allowed false conclusions to spread. They claimed reputational harm. My lawyer called it what it was. Pressure. He said they were not trying to win. They were trying to exhaust me. They were trying to force engagement. They were trying to pull me back into a conversation I had already ended. I asked him what would happen if they filed. He said we would respond with evidence. I asked him if we would win. He said yes. I asked him how long it would take. He said too long. That night, I went back to my grandfather's study again. I reread the letter he left me. I reread the notes in the margins of financial records. I reread the sentence about nothing ever being enough. Then I opened a folder I had not shown anyone. It contained a complete timeline he had prepared. Dates, amounts, visits, missed visits, requests, excuses. At the end of the file was a note written in a steady hand. If this becomes public, do not defend me. Let the record speak. I understood then what he had expected me to do. And I knew exactly how this would end. The next morning, my lawyer filed a single document. It was not a response to the media. It was not a counterclaim. It was a notice of record release. He attached every document my grandfather had prepared, the calendars, the payment history, the written explanations, the timelines, the letters he never sent. Everything was filed as a public record exhibit tied to the concluded case. Nothing was summarized. Nothing was edited. Nothing was explained. The record spoke for itself. By noon, the same journalist who had contacted me earlier requested a follow-up. This time, she did not ask questions. She asked for confirmation that the documents were authentic. My lawyer confirmed. The second article went live that evening. This one included dates, numbers, direct quotations, screenshots of handwritten notes. It showed the monthly transfers. It showed the gaps between visits. It showed promises that were never kept. It did not accuse anyone. It did not need to. By the next morning, the tone changed. Commentary shifted from speculation to silence. Posts were deleted. Threads were locked. The story stopped spreading. My parents' lawyer sent a brief email, withdrawing any intent to pursue further claims. No explanation was included. That afternoon, my mother called again. This time, her voice was controlled. She said she did not expect me to release everything. She said she thought I would protect family privacy. She said I had gone too far. I told her the documents were already public. I told her nothing had been added. I told her nothing had been altered. She said people were judging her. I told her the court had already judged the facts. She said my grandfather would not have wanted this. I told her he prepared it himself. She was quiet for a moment. Then she said she needed to know one thing. She asked if I hated her. I told her this was not about hate. I told her it was about ending something that should have ended years ago. She said she did not recognize me anymore. I told her she never tried to. That was the last phone call. 3 days later, my lawyer received confirmation that all pending matters were closed. No appeals, no filings, no claims, no correspondence. The case was finished in every sense that mattered. That evening, I returned to my grandfather's house and packed the last remaining files into storage. I locked the study for the final time. What followed was not relief. It was quiet. And for the first time, nothing was waiting to reopen itself. For several months after everything went quiet, nothing happened. No court notices, no emails, no indirect messages through lawyers or journalists. The silence was complete, and that was what made it feel unstable. I had learned that with my parents, silence was never peace. It was delay. Then my office security called me one morning. They said 2 people were in the lobby asking to see me. They gave my name. They said it was urgent. They said it involved family. I told security I was not expecting anyone. They described them anyway. It was my parents. I did not go down immediately. I asked security to keep them there and to record the interaction. When I arrived, my parents were standing side by side near the reception desk. They did not look surprised to see me. They looked prepared. My father spoke first. He said they were not there to argue. He said they were there to fix things privately. I asked them what that meant. My mother said she wanted to settle everything outside of courts and public records. She said there had been enough damage. She said we could still keep the rest quiet. I asked what the rest was. She said she knew my grandfather had left more material than what was released. She said she wanted assurance that nothing else would surface later. I told her there was nothing else. She said she did not believe me. My father said we could sign an agreement, mutual silence, no more documents, no more disclosures. He said it would protect all of us. I told him the matter was already closed. My mother said closure required cooperation. I told her closure required acceptance. She said she was willing to apologize if that was what it took. She said mistakes had been made on all sides. I asked her to be specific. She did not answer. My father interrupted and said apologies were not productive. He said practical solutions mattered more. He said we were all adults and could handle this sensibly. I told them they needed to leave. My mother's expression hardened. She said I was forcing her hand. She said she did not want to do this publicly, but she would if necessary. I asked her what this was. She said people still cared about stories involving judges and money. She said public interest never truly disappeared. She said there were always new angles. I told her security would escort them out. As they were leaving, my father turned back and said one sentence. "You think you ended it, but you only delayed it." That afternoon, my lawyer called. He said someone had contacted him asking about the possibility of a memoir. Not mine. My mother's. And that was when I realized the story was about to change again. The inquiry about the memoir did not come with a manuscript. It came with an outline. My lawyer forwarded it to me the same day he received it. It was not detailed, but it was clear enough to understand the direction. It framed my mother as a young woman forced into motherhood. It framed my grandfather as controlling. It framed me as distant, ambitious, and calculating. It did not mention court rulings. It did not mention dismissed filings. It did not mention evidence. It presented the story as unfinished and unresolved. My lawyer contacted the publisher listed on the inquiry. He informed them that every legal dispute related to the estate had been resolved and documented. He warned them that any false claims could expose them to liability. The publisher responded carefully. They said the project was exploratory. They said nothing had been signed. They said they would proceed cautiously. 2 weeks later, a podcast episode was released. My mother did not name me. She did not name the court. She spoke in general terms about betrayal, about being erased by a system that favored power and influence. She implied that certain records had been hidden. She implied that silence had been enforced. People connected the dots anyway. Messages began appearing again. This time they were more divided. Some believed her. Some asked why the courts had ruled the way they did. Some began searching for public records. The documents were still there. That slowed things, but it did not stop them. My lawyer advised me to prepare for escalation. He said public narratives followed different rules than courts. He said truth still mattered, but timing mattered more. Then a letter arrived at my home. It was handwritten. My mother wrote that she was tired. She wrote that she did not want to keep fighting. She wrote that she only wanted acknowledgement. She wrote that she felt erased by my grandfather's final choice. She wrote that she deserved to be seen. At the bottom of the page, she asked me to meet her alone. I did not respond. 2 days later, another letter arrived. This one was shorter. She wrote that if I refused to meet, she would tell her story fully and publicly. She wrote that she would no longer protect anyone. She wrote that the truth would come out whether I cooperated or not. I forwarded both letters to my lawyer. He responded with a question. Do you want to stop this, or do you want to finish it? I did not answer immediately. That night, I opened the storage box containing the last materials my grandfather had prepared. Inside was a sealed packet labeled with a single word. Final. I had never opened it. Until now. And I understood why he saved it for last. The packet labeled Final contained 3 items. The first was a notarized affidavit written by my grandfather. It was dated 1 year before his death. In it, he stated clearly and without emotion that he was of sound mind, that no one influenced his decisions, and that his relationship with his daughter had been distant by her own choice. He listed dates. He listed amounts. He listed missed visits. He stated that his granddaughter had never asked for money, property, or advantage of any kind. The second item was a recorded transcript summary prepared by his attorney. It referenced a private meeting where my grandfather anticipated future attempts to control the narrative. He stated that if public claims were made after his death, they should be answered with documentation, not debate. The third item was a sealed instruction. It was addressed to me. He wrote that if his daughter attempted to publish or speak publicly in a way that misrepresented events, I was authorized to release the affidavit and supporting records in full, without redaction, and without further notice. He wrote that this was not retaliation. He wrote that it was containment. The next morning, my lawyer reviewed everything. He said the affidavit alone would end the memoir, the podcast, and any further attempts to imply wrongdoing. He said it was decisive. He also said once it was released, there would be no undoing it. I asked him what would happen to my mother afterward. He said that was no longer a legal question. That afternoon, the publisher contacted my lawyer again. They said my mother was pushing to move forward quickly. They said she claimed to have documentation supporting her version of events. They asked whether we intended to contest publication. My lawyer replied with one sentence. We will publish first. The affidavit was filed as a supplemental public record connected to the original probate case. The release included timestamps, notarization, and attorney certification. Nothing was summarized. Nothing was explained. Within hours, the publisher withdrew interest. The podcast episode was removed. Requests for interviews stopped. That evening, my mother called. I did not answer. She sent a text message instead. It contained only one line. I didn't think he would do that. I read it once and did not reply. 2 days later, her publisher formally terminated discussions. The memo cited credibility concerns. A week later, her lawyer sent a short email confirming there would be no further public statements, publications, or claims. The story ended where it should have ended years earlier. But I knew something else was coming. Because people who lose control do not accept silence easily. They look for one last move. And my mother still had one left. The last move came quietly. No lawyers. No publishers. No courts. It came through the mail. A certified envelope was delivered to my home address late on a Friday afternoon. It was sent by my mother. Inside was a single document and a short note. The document was a handwritten will. Not my grandfather's. Hers. In the note, she wrote that she was updating her estate plans. She wrote that she wanted me to be aware of her intentions. She wrote that she was leaving me nothing. She wrote that she was donating what little she had to charities and naming distant relatives as beneficiaries. She wrote that this was not revenge. She wrote that this was closure. The will itself named my father as executor. It also contained a statement. It said that she disinherited me because of betrayal, manipulation, and refusal to reconcile. I read it once and set it aside. The following Monday, my lawyer contacted me. He said my mother had filed a copy of that will with the county clerk. He said she had also submitted a written statement requesting that it be preserved as evidence of intent in case of future disputes. He paused before saying the next part. He said the filing included an attachment. The attachment was a personal declaration accusing me of coercion, emotional abuse, and public humiliation. It claimed that I silenced her. It claimed that I controlled access to information. It claimed that fear prevented her from speaking openly. It did not request action. It created a record. My lawyer said this was not a lawsuit. It was positioning. He said she was creating a trail that could be used later if anything happened to her. He said it was designed to imply cause without making claims that could be challenged immediately. I asked him what we needed to do. He said nothing. He said responding would give the document weight it did not yet have. 2 weeks later, another letter arrived. This one was shorter. My mother wrote that she was unwell. She wrote that she had been diagnosed with a heart condition. She wrote that time felt limited. She wrote that she did not want to leave this world without being heard. She asked again to meet. I did not respond. A month passed. Then another certified letter arrived. This one was from my father. He wrote that my mother's health was declining. He wrote that she talked about me constantly. He wrote that he believed reconciliation was still possible. At the bottom of the page, he added a sentence. If something happens to her, you will regret this. That was the first time a threat was stated plainly. I forwarded the letter to my lawyer. He told me to document everything. He told me to prepare. Because when people believe time is running out, they stop caring about consequences. And that was when I understood that the final confrontation would not be legal. It would be personal. The confrontation did not happen where I expected it. It happened at my grandfather's house. I arrived one evening after work to check on the property. The house had been empty for months. No one else had keys. When I pulled into the driveway, a car I did not recognize was parked near the curb. The front door was unlocked. I did not go inside immediately. I called my lawyer first. He told me to leave and contact local authorities. I told him I needed to see what was happening first. I stepped inside. My parents were in the living room. My mother was sitting on the couch. My father stood near the window. They did not look surprised to see me. They looked like they had been waiting. I asked how they got in. My father said the door was open. I asked why they were there. My mother said she needed to see the house one last time. She said she wanted to feel close to her parents again. She said time was short. I told them they needed to leave. My mother said she would after we talked. She said she had read the affidavit. She said she knew my grandfather had planned for everything. She said she understood now why she lost. She said she was not there to argue. She said she wanted acknowledgement. I asked what that meant. She said she wanted me to say that she mattered to him. She said she wanted me to say that his final decision did not erase her. I told her his decisions spoke for themselves. She said that was not enough. My father stepped forward. He said we could end this quietly. He said she was sick. He said stress made things worse. He said refusing her now would stay with me. I told him to stop. My mother stood slowly. She said she carried me for 9 months. She said that had to count for something. She said biology could not be erased by paperwork. I told her raising a child counted more. Her face changed. She said if I walked away again, she would tell everyone I abandoned her when she was dying. I told her that would not change the record. She said people believed stories more than documents. I told her people believed patterns. She reached into her bag and pulled out a folded paper. It was a draft statement. She said she planned to release it if I refused to speak publicly with her. She said she wanted 1 photo, 1 interview, 1 appearance together. She said that was all. I told her no. I told them both to leave. My father argued. My mother began crying. Neither moved. I stepped outside and called the police. When I returned, my mother was sitting again, silent now. My father watched me without speaking. The police arrived within minutes. I told them the house was mine and that my parents were trespassing. They were escorted out without resistance. As my mother passed me, she said quietly, "You chose this." I did not answer. That was the last time I saw her alive. 2 weeks after that night, my father called. I did not answer. He left a voicemail. He said my mother had been admitted to the hospital. He said her condition had worsened suddenly. He said doctors were concerned. He said she kept asking for me. I did not respond. The next day, my lawyer called instead. He told me my father had contacted him. He asked whether my presence at the hospital would change anything legally. He asked whether any statements made there could be used later. My lawyer told him no meeting would change the record. That afternoon, another call came. This time, it was from the hospital. They said my mother had listed me as next of kin on an intake form. They asked if I would come. I told them to remove my name. They asked who should be contacted instead. I told them my father. That night, an email arrived from my father. He said she was asking to see me. He said she was afraid. He said this was not about documents or stories anymore. He said this was about a daughter and a mother. I did not reply. 3 days later, my lawyer called early in the morning. He said my mother had died overnight. He said my father wanted to speak to me. I said no. He said there was a will. I said I knew. He said my father was the executor and would handle everything. He said my name was mentioned. I asked how. He said there was a letter addressed to me. I said I did not want it. My lawyer said he would keep it on file unopened. The funeral was announced publicly. I did not attend. My father did not contact me again. 2 weeks later, a final filing appeared in the county records. My mother's estate was closed. There were no disputes. There were no challenges. There was no mention of me beyond the disinheritance clause. The record ended quietly. Months passed. Nothing else happened. No articles. No interviews. No letters. The story did not continue. It stopped. And for the first time since my grandfather died, there was nothing left waiting to surface. Only one part remained. And it had nothing to do with them. After my mother's estate was closed, my lawyer returned the unopened letter to storage with the rest of the files. Nothing else arrived. No delayed claims. No last statements, no attempts to reopen anything. The silence this time did not feel temporary. I returned to my grandfather's house one final time to prepare it for sale. Every legal matter connected to it had ended. There were no conditions attached anymore. The house was just property now, not a battlefield. While sorting the remaining items, I found one last envelope tucked behind a row of old law books in the study. It was not sealed. It was not labeled. Inside was a single handwritten page in my grandfather's writing. He wrote that some conflicts do not end because someone wins. They end because time removes the people who refuse to let go. He wrote that I was not responsible for carrying unfinished business that was never mine. He wrote that choosing distance was not cruelty when closeness had only ever been used as leverage. At the bottom of the page, he wrote one sentence. Live without explaining yourself. I placed the letter back where I found it. The house sold 2 months later. I did not attend the closing. My lawyer handled it. The funds were transferred quietly. No one contested anything. No one asked questions. My father never contacted me again. Years passed. The case stopped being referenced. The articles disappeared into archives. The documents remained public but untouched. There was nothing left to argue about. I continued my work. I built a life that did not require correction or defense. When people asked about my family, I answered briefly and moved on. No one needed details. On the anniversary of my grandfather's death, I visited his grave alone. I stood there for a few minutes and then left. There was nothing left to promise and nothing left to protect. What ended was not a lawsuit or a feud. What ended was the expectation that I owed anyone access to my life. The story did not close with reconciliation. It closed with finality. And nothing followed after that. You have reached the end of the text.